Announcement of judgment, item number 1.
For reasons mentioned in the judgment, the appeal is partly allowed. The rate of interest awarded on the awarded compensation is increased from 7.5% per annum to 9% per annum.
Item 2 and 3.
For reasons mentioned in the judgment, the impugned order dated 25/1/2024 passed while the Court of Learned Civil Judge Senior Division, Dibrugarh in Miss J case number 15/2024 is hereby set aside, and the CRP IO number 54 as well as 60 are accordingly allowed. Yes, any mention?
That's on item 53. There is a date fixed for Shazai. Shazai is not available.
Heard Mr. T. Hussain, learned counsel for the petitioner. Also heard Mr. D. Sharma, D.P. Sharma, B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let the case be listed on.
Lordship, the petitioner is already on interim. So, Lordship, can it be on 24th or 25th?
25th of July. The interim order shall continue till next day.
As I pray for listing of 3 anticipatory bail applications arising out of the same FIR. I filed it during the vacation hours. Then can it be taken up on Wednesday morning?
What is the matter?
It's relating to Prevention of Corruption Act. It pertains to Arunachal Pradesh. The Arunachal Pradesh bench is on vacation right now. Sanction has already been issued against the 3 officers. But in spite of that, the police is calling them, so they apprehend that they will be arrested.
No, registry will be listing it otherwise.
There is some urgency. Can it be taken up on Wednesday morning?
Okay.
I believe. On item number 26, forward to the petition.
Item number 26. What is your prayer?
Lordship, what to the typically mistake in the first.
You want to withdraw the case. What is your name? What is your name?
Islam.
Yes, I Islam. Heard Mr. I Islam, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Lordship, I beg to mention 2 anticipatory bail applications for withdrawal. AB 145125 and AB 128125. Tomorrow.
Okay. Okay.
May it please your Lordship. Lordship, I beg to mention item number 16 of the daily list. Lordship, matter may be withdrawn, Lordship. Liberty to file.
What is your name?
A. Ghoshal.
Heard Mr. A. Ghoshal, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Liberty may be given.
Liberty in criminal cases is not required. For filing bail, if you are behind the bars, you can file bail application at any time.
Nice one.
I think for a, listing for bail application, my lord.
What is the matter?
NDPS, my lord. 1 year, 7 months is already granted. Similar co-accused has already granted bail by this court. Same co-accused. There are two accused persons, one was already granted bail. So, my lord, this may be listed.
When?
Witness day.
Okay.
Obliged. Wait, Mr. Lordship, I went to mention for listing of bail application on 16th, that is Wednesday,
What is the matter?
NDPS.
Fresh matter.
Lordship.
Fresh matter.
Lordship.
When have you filed?
It's actually not fresh, it's a long pending complaint. It's on pending
When have you filed it?
5th of March.
Okay.
Public.
Daily list motion be item 4. In item 4, lordships already available, lordship.
CD is available.
Yeah, it was already called for, lordship.
Just come.
Yes, yes, yes.
Yes, Miss.
But the FHL is not there, lordship.
Yes, Mr. Vishwas.
That
What is your case?
is that I am not an accused. I am the owner of the vehicle. And nothing was found. But
When were you arrested?
Michael, I was arrested, my lord, in the on 29/5. My lord, your lordship will peruse the CD, my lord. Because the co-accused said that, driver and handyman said that vehicle belongs to me. And something, the mechanization done by me, that is delegation. To keep the contrabands inside the vehicle.
How many days you are behind the bars?
My lord, since
What is the contraband? How much?
0.6 grams.
Moreover, I want to clarify, Lordship, in the FIR, it is clearly written that the person apprehended the driver, namely Gulab Wajid Borguya, the present petitioner. He was there. He has stated that, Lordship, my Lordship.
What has happened to other co-accused?
They are behind the bar. Driver and handyman.
It is not that he is only the owner, Lord. He is also present at the spot.
No, diary does not disclose like that. As far as it is.
Okay, why your prayer was rejected by the trial court?
Because my lord, the trial court rejected me, that is a fresh case, my lord, and moreover, there is a co-accused delegation is there against me. That I have instructed them to carry the contraband goods and to keep a hole inside the vehicle.
Who-
That is a driver.
How many days you are behind the bars?
From 29/5, 46 days.
Yes, Miss. What is the progress?
Their Lordship, it is many other persons are also involved as per CG. So his custody implication is necessary. Otherwise,
But he is behind the
Behind
bar
the
for
bar.
last 46 days.
Lordship, it is true, but FSL is also not received.
Assuming that FSL is positive. Let us assume that it is positive.
However, Lordship, the Caesar witnesses are also there. They also implicated, Lordship. And it is an intermediate quantity, Lord.
So you can detain him for 14 more days.
Lordship.
Why do you need that detention?
For the further investigation, Lord. Therefore, but for court hold of other persons, Lordship, who are involved. Because these are the crimes, Lordship, which cannot be done unilaterally, Lordship. Other persons are needed for carrying out such activities. Lordship.
Heard Mr. S. C. Vishwas, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Ghulam Wazid Bordhuya, who is detained behind the bars since 29/5/2025, within bracket for last 46 days, in connection with Sonai PS case number 43/2025 under section 21B of the NDPS Act. The gist of accusation in this case is that on 29/5/2025, one Bishwajit Nath, SI of police, had lodged an FIR before the officer in charge of Sonai police station, inter alia, alleging that on receipt of an information through reliable sources that a black Jimny vehicle bearing registration number AS11AB 7330 is involved in transporting suspected heroin from Swadhin Bazar to Silchar. Accordingly, a Naka checking was organized, and during Naka checking, the said vehicle was intercepted. During the search of the said vehicle, 62.06 grams of suspected heroin was found
Inside the vehicle.
inside the vehicle, and the present petitioner, you were also inside the vehicle.
No, I was not there.
What is your name? Ghulam Wazid Barbhia?
Yes.
The forwarding also it is stated that he is caught red-handed, Lordship.
Why you are saying you are not there,
Yeah, forwarding also, dear Lord.
Mr. Bishwas?
But I was arrested later on.
But FIR mentions about you.
Lordship,
Please,
and
the
there is
FIR
a
wrong.
forwarding also, Lord.
False FIR has been lodged, my lord.
Lordship, may look into the forwarding also, Lordship. It is clearly stated in the ground of
And
arrest.
no
point
grounds of
number
arrest
one.
was handed over to me also. my lord.
In point number 1, reason for arrest, ground of forwarding also, Lordship. The arrested request was caught red-handed while carrying the said NDPS, Lordship.
You were driving the vehicle.
Lordship.
No, it was driven by some other person. His name is also not there.
Let it be investigated.
Lordship.
Why are you opposing the bail?
Lordship, because other persons are also there.
Okay.
And my lord, much progress has been done regarding the investigation. 46 days.
No, you have made wrong submissions before the court. You were caught red-handed in the vehicle.
That is the information given by the IO. But actually, I was arrested subsequently
When?
on 29/5.
From 29/5. 29/5, from where you were arrested?
Well, when I inquired about the vehicle, I was arrested. Because Naga checking vehicle was detained.
Okay. क्या लिखा है बोलना? And the driver, that is the petitioner, was arrested from the vehicle itself. Stop. Learned counsel for the petitioner has submitted that where have you mentioned that you were not driving the vehicle in the petition? Learned counsel for the petitioner has submitted that he is the owner of the vehicle
Yes.
which was seized in connection with this case. However, he is not involved in this case. He has also denied the fact that he was arrested from the vehicle. Learned counsel for the petitioner submits that the petitioner was arrested when he went to the police station to inquire about the vehicle, inquire about his vehicle which was seized in connection with this case. Where is that statement that you were arrested later on? Learned counsel for the petitioner has further submitted that the
748 has not complied.
that
It is complied, Lordship.
Show me,
I will.
I will also show you.
that notice under section 47 and 48 were also not given to the petitioner at the time of his arrest. He has submitted that considering this period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of the Sonai PS case number 43/2025 and has submitted that the petitioner was caught red-handed in the vehicle as he was driving the vehicle which was seized in connection with this case. He also submits that some other co-accused persons are also involved who are yet to be arrested. And if the petitioner is released at this stage, the investigation would be hampered. 47, 48 comply.
Ground of arrest has been given, page 18, madam. That is forwarding.
Find out.
Okay.
Mr. Das, you
There-
flag mark.
Okay, I flagged it. This 47 and 48. Brief of the case is also there, Lordship.
Learned counsel, learned additional public prosecutor also submits that the petitioner was furnished with the grounds of arrest.
Yeah, my signature is there, madam, or my relative signature is there. Kindly verify.
When the petitioner was arrested in this case. I have gone through the
48 করা না।
case diary. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary which was available, which has been produced by the learned additional public prosecutor. On perusal of the case diary, it appears that the petitioner was arrested from the vehicle itself. Petitioner was arrested when he was found driving the vehicle which was seized in connection with this case. It also appears that though the quantity of contraband is intermediate quantity, however, it is intermediate quantity, that is 52.6 grams. However,
62, madam,
62.6
6 gram.
62.6 gram. Your submission is not right, Mr. Bishwe.
My client, madam.
So he has to remain.
If that is so, I have to remain.
However, considering the materials available in the case diary, which incriminate the petitioner in this case and the
Let it come out of 10 days, madam, in that event.
stage of investigation, the prayer for bail is rejected at this stage. Send back the case diary.
With liberty to come.
Liberty is always there.
Item 5.
We have been. And second time before the lordship. Earlier rejected on 5/25 lordship, transited matter lordship. Trial is going on. Let me call for.
Where, where, where is the ejection order?
Page 63 lordship, 6/3. Page number 65 lordship. Lordship's order lordship.
Why have you come again?
Lordship, at that time, only part charge sheet was submitted against the petitioner. Co-accused was still absconding. Now, at present, lordship, 2 accused were arrested and charges already framed and PW 1, 2, and 3 already examined.
Okay.
And moreover, lordships, notice under section 47 and 48 was not complied. Lordship. On this ground, prisoner came before lordship.
Heard Mr. S.K. Chetri, learned counsel for the petition. Also heard Mr. B. Sharma, learned additional public prosecutor. This application. No. Perusal of the scanned copy of the case record as well as scanned copy of the case record of the trial court would be necessary for consideration of the instant bail application. Hence, call for the same. Registry to issue requisition for the scanned copies. Let this matter be listed again on 31/7.
Additional session just Golpara.
Item 12 is same.
Item 12. Item 12 heard Mr. Z. Hussain. Also heard Mr. B. Sharma, learned counsel, additional public prosecutor. Call for the scanned copy of the records of the trial court and list this matter again on 31/7/2025 along with bail application number 2091/2025.
Item 6.
My lord, I take the petition to withdraw this case.
What is your name?
A. Datta.
But your name is not there in the. You have filed wakalatnama in So the counsel who has signed wakalatnama can only withdraw the case. We'll list it again.
Behalf of the Lord,
Who authorized you?
and the way,
Huh?
way.
Why he's withdrawing?
He wanted bail in lower court.
Heard Miss, what is your name? A. Datta, submitting on behalf of Mr. N. Dubey, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Item 7.
So this is a charge-sheet case. Is behind the bar for 2 years, 3 months. The case is registered under NDPS case law. The 4 of the co-accused have been released on bail. I mean, including here the judge.
Yes, NCB.
Scan copy lodge.
What is the progress of the trial?
Only 3 numbers of witnesses have been
Heard Mr.
taken.
K.K. Hendik. K.K. Hendik, learned counsel for the petitioner. Also heard Miss N. Kakoti, learned counsel for NCB. This call for the scanned copy of the case record of NDPS case number 133/2023 from the learned trial court. Registry to take steps for requisitioning the scanned copy. Let this case be listed again on 4th of August.
Review. Item A.
Please, your lordship. Lordship, FIR is at page 11. Next on the POCSO section 6 is there. So case record is being released.
It is a charge sheeted or under
Yes,
investigation. Then heard Mr. S.N. Tamoli, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Since this case involves offense under POCSO Act, issue notice to the respondent number 2. As per the prevailing notification in this regard, the petitioner shall take steps for issuance of notice accordingly within how many days? Within 3 days from the date of this order, returnable on 30 July. Stop. Let the case diary of Gosaigaon PS case number 184/2024 be also called for. Let this case be listed again on 30 July 2018.
Item 9.
In this case, my lord, petitioner registered on suspicion, my lord, FIR is page 13. A case of murder case, my lord.
Murder case.
Murder case.
It is, investigation is going on.
My lord, charge sheet is submitted, charge already framed, my lord, and he was arrested on 9/11/24. FIR page 13.
9/11.
9/11/24. 8 months. And then page 13.
What is the stage of the trial?
Examined, my lord, yeah, it is, my lord, 8 occasion, my lord, I have, my lord, encouraged this copy obtained from net, my lord, that it is for production of, with production of baby. Today also it is fixed.
Why your prayer was rejected by the trial court?
It is, my lord, here, my lord.
Where is the rejection order?
16. Page 16, my lord.
But at the time of initial investigation also, at that point of time.
Yes.
Now, after filing of charge sheet, have you not filed bail application?
No,
You file before the trial court. Go approach the trial court. If it rejects, then come to this court.
once it is rejected.
It was rejected during investigation stage. If now your stand is that you are arrested on suspicion, after filing of charge sheet, you again pray before the trial court, then come to this court. Yes, what is the submission? Mr. Chauhan.
My lord, my lord,
Because if this court rejects the bail application, it is unlikely that you will get relief in trial court thereafter.
my lord, right of date you also can consider.
Okay, heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Considering the nature of offense involved in this case, perusal of the scanned copy of the case diary of which police station case?
Kolaigaon PS case
Ko-
77 of the.
Kolaigaon PS case number 77/24 would be necessary. Hence, call for the same. Also call for a status report of the trial whether case has been committed to the sessions court?
Yes, already Lordship charges have been.
Okay, okay. Status of the trial from the trial court. Registry to issue the requisition for the same. Let this case be listed again on 4th of August.
One thing maybe. Remember, he was holding a dog.
We have called for the scanned copy of the.
With his lordship. With his lordship.
Yes.
This is application under section 483 of BNSS lordships. Allegations in the FIR are under procedural lordship. So notice may be issued.
Heard, Mr. What is your name?
Say Riaz lordship.
S. A. Riaz, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for the case diary. Also issue notice to the respondent number 2 in accordance with the prevailing notification in this regard. The petitioner shall take steps for issuance of notice to respondent number 2 accordingly within 3 days from the date of this order, returnable on 30 July. Let this case be listed again on 30 July.
Item 11.
Make his lordship. The application number 483. Allegation, under section 21C. Lordship,
Is it a charge sheeted case?
pending before the learned, petition on district and session lordship.
NDPS case.
Lordship.
What is your ground?
At the time of arrest,
Be louder. You have covered the mic with your book.
my lord, at the time of arrest, the ground of arrest was not disclosed to the accused person's lordship.
Heard, Mr.
Please, no.
A. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional
Lordship,
public.
we are not appearing customs.
Okay. NCB is not there. You have issued notice to NCB. And none has appeared for the custom. You are appearing. You have received copies. You have not furnished copies of bail application.
Yes, lordship.
You have not served.
Served.
Yes or no?
Yes, lord.
Also heard Miss M. Kakoti, N. Kakoti appearing on behalf of Mr. S.C. K.L., learned standing counsel, Customs Department, who submits that she has not received the copies of bail application. The petitioner is directed to furnish the copies of bail application along with annexures to the learned counsel for Customs Department. Stop. Call for this is a charge sheeted case, no?
Yes, lordship.
Call for the scanned copy of the case diary as well as scanned copy of the trial court's record from the trial court. The registry to send requisition for the same. Let this matter be listed again on 5th of August 2025.
Item 13.
Please, your lordship. Lordship, this is 483 application, lordship, 179 days behind the bars, lordship. Lordship, charge sheet case, lordship. Case record will be needed. Lordship. The offense is under Arms Act and Explosives.
Heard Mr. P.K. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for the scanned copy of the trial court records from the trial court. Registry to issue requisition for the same. Also call for the scanned copy of the case diary of Gosaigaon PS case number 152/2015. Let this case be listed again on 5th of August. 30 July.
Obligation, deeply obliged.
14.
Lordship, madam, pass over for time.
Why?
The senior is out. Another
It is a
NDPS matter, lordship.
NDPS.
Lordship,
Okay. After some time.
deeply obliged.
Item 15.
Please, your lordship, this is.
Heard Mr. What is your name?
Islam.
Heard Mr. A. Islam. Yes, what is the submission? Also heard Ms. N. Kakoti, learned counsel for NCB. Let the scan copy of the trial court records be called for, along with the scan copy of the case diary. Registry to issue requisition for the same. Let this matter be listed on 6th of August.
Yes, Lordship.
Item 17.
Yes. 17.
Lordship. Case diary is again.
Today is the motion day.
Lordship, kindly this matter may be taken up with bail application number 1919, 2025.
Item number
Item number 17, my lord.
17 has been adjourned. No, this is 17.
17. This 17.
It should be taken up with which item?
Bail application number 1919.
Why?
Last posted on 26.
May I please, your lordship? Lordship, similar cases pending before this honorable court.
When?
It is given the immediate lordship. So this matter may be come up with this number, PA number 1919, 2025. Similar cases pending.
Heard Mr. What is your name? K. Zaman, learned counsel for the petitioner, who submits that another bail application, that is BA number
1919.
1919 of 2025 is pending in respect of the same case, same police station case, and therefore he prays that this matter may be listed along with the said bail application. The prayer is allowed. Registry to list this bail application along with bail application number 1919/2025 on the date fixed in the said case.
Item
18.
483 application, my lord. Basically this petition, my lord, in connection with the NI case, my lord. When filed the NI case, that case was succeeded, my lord. And thereafter, my lord, in connection with the judgment of the NI case, my lord, he was, my lord, arrested. As
Judgment means of
the-
for serving out sir sentence.
Yes.
You have not filed an appeal.
My lord prepared an appeal, my lord. The appeal was dismissed, my lord.
Appeal was dismissed.
Yes.
Then this bail application is liable to be
My lord,
dismissed.
Sir, kindly come to page 73, my lord. This is the order passed by the, my lord, trial court. He appeared, my lord. He was taken into custody. Lord, today is 46 days, my lord.
What is the punishment?
Amount was, my lord, the check amount.
No, what is the imprisonment? 6 months. And today is 46 days. You have to spend 4 months and some days more.
Yes.
Where is your appeal rejection order?
I have not annexed, my lord. My lord, one page order, my lord. This is the
Page
the 3-4, can you say? 3-4 sentence. I have stated, my lord, in petition, my lord.
Paragraph 12 and 13 also.
Unless the sentence is suspended, how can you be released on bail?
Was dismissed, my lord.
So your case
But
has,
now he approached, my lord. Lord, he would approach by filing a revision petition.
before,
Before the High
he
Court
will approach,
approach.
then approach.
Already handed over the documents, my lord.
This application is not maintainable.
And in the meantime, my lord, he was taken into custody. So now 46 days, my lord.
Your punishment is
He
6
will
months.
comply with the judgment, my lord.
You are complying with the judgment actually. You are serving out your sentence. Heard Mr. S.A. Ahmed, learned counsel for the petitioner. Where is the
He is in jail.
where is the order of the appellate court?
Appellate court, not annexed, my lord.
Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the
Pursuant to the order dated 29/5/2025, case 73.
लिखा मुन्नू has been filed by the petitioner who has been detained behind the bars since 29/5/2025 in connection with NI case number 92/2017. Learned counsel for the petitioner has submitted that the petitioner was sentenced to
Not sentenced, my lord. But, case 69, I have annexed the copy, my lord. There it mentioned that if default to pay the compensation, in default of payment of fine, 6 months, simple imprisonment. Case 69, my lord. Only fine was imposed, my lord.
was sentenced to pay a fine of rupees 8,55,000 and in default of payment of fine to undergo undergo simple imprisonment for 6 months. Learned counsel for the petitioner has submitted that the petitioner had preferred an appeal against the said judgment of the trial court, that is within bracket judgment dated 26/4/2023 21/7/2023 passed in NI case number 92/2017 bracket close. The said appeal was registered as criminal appeal number 31/2023. Stop. Learned counsel for the petitioner has submitted that on 20/23/2024, the appeal was dismissed by the appellate court. Stop. He further submits that when the petitioner appeared before the trial court on 29/5/2025, he was taken into custody and was remanded to the jail to serve out his sentence. Stop. Learned counsel for the petitioner has submitted that the petitioner is intending to prefer a revision against the judgment against the order of the appellate court. However, as he has already been detained behind the bars, he has prayed for releasing the petitioner on bail. Stop. It appears that the petitioner was sentenced to pay a fine and in default of payment of fine to undergo simple imprisonment for 6 months. It also appears that the petitioner has defaulted in payment of fine and therefore he has been taken into custody. Stop. It also appears that the appeal preferred by the petitioner that is criminal appeal number 31/2023, has also been dismissed by order dated 23/2024. Stop. Though the appeal intended to prefer a criminal revision, however, same has not yet been preferred. Under the above facts and circumstances, this case is not a fit case to grant bail to the petitioner, as said jurisdiction is of either appellate court or of the revisional court after passing of the judgment in the appellate court, whereby the appeal has been dismissed. This bail application is therefore devoid of any merit and accordingly dismissed.
This undergo exempted the fine.
I'm not getting you what you want to say. What is your,
He completed his 6 month imprisonment. My lord,
you read, you do your research that if he undergoes 6 month sentence, whether he will have to pay fine or not. Do your research and answer this question on your next appearance before me. Okay?
Item 19.
four 83 petition, my lord. In this case, my lord, the case was, my lord, initially, then a complaint case was filed, my lord, against the instant petitioners, my lord. And thereafter, the same complaint case was forwarded to the police station, and thereafter, my lord, case has been registered. And subsequently, my lord, the section 6 of POXO case has been added, and after investigation, case has been charge-sheeted, my lord. And now, my lord, the petitioner was, my lord, on asking by the police officer, my lord, he has voluntarily appeared before the police station, my lord. And thereafter appeared on, my lord, 29/3/2025. My lord, on the same day, my lord, he was forwarded to custody, my lord. And thereafter, my lord, just after 2 days, charge sheet has been submitted. Now, my lord, recently POXO case has been registered, a special POXO case has been registered, and the case has been fixed for, my lord, production, my lord. Not a single, my lord, witness has been examined, my lord, and the petitioner has already, my lord, is in bar, my lord, for 108 days, my lord.
okay, heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma. Since this case involves an offense under POXO Act, let the notice be issued to respondent number 2. Who is respondent number 2?
So to they say, father of the victim.
Victim. Respondent number 2. Stop. The petitioner shall take steps for issuance of notice upon respondent number 2 in accordance with the prevailing notification in this regard within 3 days from the date of this order, returnable on 4th of August 2025. Stop. Let also the scanned copy of the case diary as well as a status report of the trial in special POXO case number 34/2025 be called for from the trial court registry to issue requisition for the same. List accordingly.
That is, my lord, yeah, case number may kindly be noted, my lord.
No,
Several cases, my lord.
registry.
Obvious, my lord. Much obvious.
Item 20. Charge-sheet matter, lordship.
Please, lordship, charge-sheet case, lordship, say, call for the same to me.
What is the matter?
Commercial quality, lordship,
NDPS.
NDPS.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for this scanned copy of the case record, trial court records from the trial court. Registry to issue requisition for the same. Let this matter be listed again on 7th of August.
Your lordship. A petitioner is behind the bar for the last 62 days, lordship.
62.
62 days, lordship. In this case also, the mandate of section 47 has not been complied with properly, lordship.
Notice to go.
It is a- It is a
POSCO matters.
charge sheeted case or pending invest.
Pending case, lordship.
CD requirement. CD and notice to go.
Okay. Heard Mr.
P board.
P. Bordolo, learned counsel for the petitioner. Since offense under POXO Act is involved in this case, let the notice be issued to the respondent number 2. In pursuant to the prevailing notification in this regard, the petitioner shall take steps for issuance of notice within 3 days from the date of this order accordingly, returnable on 25th of July 2024. Let also case diary be called for. List accordingly.
Oblige, your lordship.
Item 22,
Please, your lordship. May I please, your lordship. Lordship, 483 application, lordship, matter pertains to seeking regular bail in connection with special POCSO case number 16 of 2024, your lordship. I was arrested 4th February 2024, your lordship, 17 months of trial. The trial has initiated in the last year, August, lordship. 20 dates has been passed, lordship, and I've annexed all the orders of the court, lordship. And 2022 dates, the PWs are absent. I've annexed all the orders, your lordship. I'm in judicial custody since 4th of August 2024, your lordship. More than 500 days. Lordship will call for the case record if
Can be necessary, my lord, otherwise,
and medical report also I have annexed, your lordship. There is no sign of lordship interpose and lordship, and in defense cross examination also the informant's version is lordship.
Why it is A,
Lordship,
AB, okay, okay.
PW1 no.
PW1, only PW1, your lordship.
PW1 is the victim.
No, informant,
Informant.
part of the victim. Lordship, his deposition is already deposed.
You have annexed that.
Yes, your lordship. Next one, E, page number 26, your lordship.
Heard. Mr.
H. Modi.
Mr. H.
Mozumdar.
Majumdar, learned counsel for the petitioner, also heard Mr. P. S. Locker. Sorry. Mr. K. K. Parashar, learned additional public prosecutor. Since this case involves offense under POCSO Act, let the notices be issued to respondent number 2 according to in pursuant to the prevailing notification in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 accordingly within 3 days from the date of this order, returnable on 31st of July. Let also a scanned copy of the trial court record be called for from the trial court. Registry to take steps for requisitioning the same. List accordingly.
If your lordship, deep level.
item 23,
Eight cases, your lordship. It's a charge sheeted matter, lordship. Section 96 BNS and section 6 Act, lordship.
Heard Ms. D. Ghosh, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. It is a charge sheeted case, no?
Yes, lordship.
What is the stage of trial?
Evidence. 3 dates have gone, but notice they have.
Since this case involves offense under POCSO Act, let the notice be issued to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall accordingly take steps upon for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 4th of August,
31st, lordship.
31st of July. 31st of July. Stop. Let the scanned copy of the trial court records be requisitioned. The registry to issue take steps for requisitioning the aforesaid record. List,
Is 83, lordship.
list accordingly.
Deep level.
item 24,
40 days, Lordship.
40 days. What is the offense?
Offense, Lordship, he was arrested. After arrest, the police has lost the FIR, Lordship.
What is the offense?
Offense, Lordship, the one under section 112.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. We'll call for the case.
My lord,
Sorted, Lord.
K.K. Parashar, learned additional public prosecutor. Call for the case. Yes, when?
this poor mother, 23rd.
Release this matter on 23rd of July.
Diploma.
Section 25.
Your lordship will find page 11, lordship. Here lordship will find that 11 persons, 12 persons are named in the FIR, and the petitioner of your lordship is accused number 3. Here in this case, the background of the case is that lordship already other persons are released on bail before, during investigation and after filing of the charge sheet, lordship. Presently, charge sheet is filed.
Charge sheet has been filed.
And that, those orders your lordship will find page 40 onwards. Page 40, lordship, and say this is during investigation. This order was passed on 3/10/2024. And then your lordship will.
What is your name?
My name is Falu Mullah, alias Anwar Hussain.
He has been shown as absconder, my lord, page 22 of the part of the FIR.
Charge sheet has been laid under what provision?
Under 302, that idea 302, now 103.
Child was coming from the tuition, madam.
In fact,
He
if
was
you-
killed, spotted death by the iron rod. He
At
was.
this stage, I am not on merit, lordship. Lordship, may I kindly see page 47, he was granted bail, lordship, after filing of charges, page 47.
I think the different thing, this is for this guy. We are for this. Only.
And page 47, lordship, may I kindly see for a moment, lordship.
He may appear, but let's pay for regular bail. We are going to.
No, I am on similar footing, lordship, may I kindly see page 47, Zakir Hussain. Because there is apprehension that if case is at committal stage, and if I appear there, that committal court will to send me to custody and thereafter committal. So because of that apprehension, I am before your lordship. And similarly situated person, Zakir Hussain, he was granted protection because of that apprehension only. Because case was pending before committal court, lordship. And paragraph 3 of that order, lordship, may kindly say, in short, the petitioner has been charge sheeted in a sessions tribal case. Page 48, paragraph 3, I am reading, lordship. The petitioner submits that if he appears before the court of learned additional chief judicial magistrate, he will be remanded to custody because this court does not have the jurisdiction to entertain his bail application. The petitioner submits that he is interested to face the trial and therefore he should be given an opportunity to contest the case. And accordingly, he was granted bail of rupees 25,000. And this present petitioner is also lordship willing to appear before the trial court, but because that case is pending for committal court, he is appearing.
What is the accusation against you?
Accusation, lordship, will kindly see the FIR, page 11.
Coordinate bench already passed the order, then it may be will by that coordinate bench.
Here this matter has listed because at the initial during investigation, they all filed one bail application, which was withdrawn, and that was withdrawn before your lordship. That additional affidavit will have filed. No, as per notification is there, lordship. 2025 notification is there. It is said rejected or withdrawn. That matter will go to that bench.
But if the,
Irrespective of that, similarly situated persons case is dealt with another bench. Irrespective of that. Your lordship referred that one of my matter to the Honorable Chief Justice for dealing with that. After that, this notification has come on 2/5/2025.
okay.
Because in that case also, I have withdrawn and that thereafter that matter.
Let's say court, high court.
And that
In the
page,
case of withdrawal also, it will go to the same court.
Yes, this was withdrawn before your lordship, additional affidavit, page 52, lordship, may I kindly see.
Why are you opposing?
But my son has been killed brutally, a school child.
No, no. Trial will go. Charge sheet has been laid. So the
Well, he'll remain absconded years after years. And one fine morning, the charge sheet has been, I'm afraid, I've got apprehension, I will be arrested, so give me the bail. I want to face the trial. Very easy. My son has gone forever, a child, school going child.
what is
What was
your
it of him?
what is the response?
He was filing bail application that already I have placed before your lordship that he has withdrawn on at that point
Bail
of time.
appeal should be
He was pursuing his legal remedies. He was not absconding, lordship.
judicial consideration.
In fact, police never visited his house.
We pray the let him appear, my lord, pray for regular sake. And honorable court will consider it according to law.
Yes, ma'am. Your lordship's order is also.
Why is he afraid to appear even?
Otherwise, my lord may call the. There is no distinguishable feature, lordship, that page 47.
In that
of
case,
the
one of
original
legal appear,
bench order.
constitutional law, support will be.
No, if he appears, the coordinate bench has granted bail because the committal court cannot grant him bail.
Yes.
What is his role in the
In the FIR,
they-
lordship, all are implicated.
All are implicated,
Similarly.
Humanly killed a child, man.
That will be proved during trial. In bail application,
But
that
the
cannot.
face of your affair,
FIR and succeed now, succeeded malad, succeed malad,
any efforts were made to arrest
Investigation
him but failed.
That probably will be the PP, lordship.
No, what is your response? Suppose you are implicated in a case
Right.
where you have actively participated in commission of offense. Offense is a offense of murder. And then you then you evade arrest. And after submission of charge sheet, you take the recourse to section 480.
There is
The
no bar in approaching the court even after lordship, he is declared.
no, there is no bar.
No bar.
But
And once
what factors the court should consider while dealing with such a bail application?
Yes, crimes.
Will it automatically grant bail because the committal court cannot grant you bail?
So here in my case, what I am placing for your lordship is that he was pursuing his legal remedy, that your lordship has seen that one application was initially filed. The others also filed, lordship. And second thing, your lordship will find that the other accused who are.
Where
similar-
is your rejection order?
Not rejected, lordship, withdrawn that page 52.
Why have you withdrawn?
Because there was some technical defect in the petition, lordship.
Okay, that is your case.
Lordship,
But to get bail in a heinous offense,
lordship.
apart from the embargo of the court, committal court in granting bail, you must also have a good case in your favor.
Yes, and in perusal of the FIR also, your lordship will find no specific allegation is there against any of the person. The victim died subsequently, not on the spot. If 12 person assaulted a person, he will die immediately on the spot, lordship. But he did not die because section 103 was added subsequently. After 14 days. After 14 days, it was added. So there was, admittedly, there was some altercation with some of the person, but not this person also. It was some other persons.
Then we have to peruse the case diary to see your role. Suppose you are the main perpetrator,
Yes, madam.
then merely because you absconded during investigation, you may not be granted bail, even if you approach. If
But
you are not the
otherwise
main
also-
perpetrator,
Otherwise also, your lordship will find in the FIR, there is no specific allegation against any of the person.
we will
And-
peruse the case diary.
Can copy may be called.
Heard Mr. A. Ahmed, learned counsel for the petitioner, who also heard Mr. K. Parashar, learned additional public prosecutor, as well as Mr. S.C. Bishwas
For info.
appearing for the informant. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking anticipatory bail as after filing of the charge sheet, the case is still pending before the committal court. And due to the embargo in section
Lordship, for 209, Redwood 437.
no 209 will not come now.
232 BNSS.
Two?
232.
Uh-huh.
232 BNSS.
What is 232?
Committal procedure.
But there is no bar here.
Where is the bar? Bar is not in 232. It is in 480.
437, that earlier 437, 480, Lordship. Regarding that opinion that he is not guilty, that is in 480,
Yes.
480 BNSS.
Last line. Embargo. Provided in section 480 within bracket 1,
Yes.
within brackets small Roman 1 of BNSS. The committal court may not grant bail in this case as one of the offense under which the case has been charge sheeted is under section 103 of BNS. 103 is there.
Subsequently,
103 of BNS. On the other,
Death and of the life imprisonment.
on the other hand, is learned counsel for the informant as well as learned additional public prosecutor has opposed the grant of bail on the ground that the offense involved in this case is a heinous offense of murder and a child has been brutally killed by the accused persons. Stop. Considering the submissions made by learned counsel for both the sides, the perusal of the case diary would be necessary to ascertain the specific role of the petitioner in the alleged offense. Stop. Hence, call for the scanned copy of the case diary from the trial court. The registry to issue requisition for the same. Let this case be listed again on which date? On 30 July 2025.
Problem.
Item 27.
Please, my lord, this is 482 application, but it is a subsequent bail application, anticipatory bail application before this honorable court.
Earlier one was,
Earlier one was rejected, my lord, that I have annexed.
where is the rejection order?
At page 39, my lord. At page 39. And relevant portion, my lord, will find at page 41.
Now, what is the new ground?
New ground, my lord. The present petitioner is 65 years old and he is suffering from several heart diseases, my lord. A copy of that I have already annexed. That apart, my lord, while preparing the first bail application, there are some vital documents that are relating to land that has not been annexed, my lord. Because if my lord may kindly come just for once to page 15, my lord, the allegation against the accused petitioner is very simple, my lord, because the accused petitioner has purchased a land from one Bibha Bora. An allegation in the affair is that NOC, which is to be obtained before the sale transaction, some fraud has been committed while obtaining the NOC. This is the simple allegation. But there is abundant evidence, my lord, that the land is originally belonged to the Bibha Bora. It is already mutated and reflected in the land records, my lord, which I have already annexed in this petition, my lord. Therefore, my lord, for today, my humble request before this honorable court to call for the up-to-date case diary and to produce the statement if there is any new witnesses that were being examined in
Okay.
connection with this.
Heard Mr. B. Deka, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner for the second time. Stop. His earlier bail application, that is AB number 1082/2025, was rejected by this court on 23/5/2025. Stop. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the same. Let this matter be listed again on
29th of July.
29 July.
Because there is a recent document which I recently. I want to find an additional document.
Learned counsel for the petitioner also prays for allowing the petitioner to file an additional affidavit to bring on record certain document which are relevant for consideration of the instant anticipatory bail. The prayer is allowed. The petitioner may file an additional affidavit before the next date fixed.
Item 28.
Same, my lord. New ground is, my lord, page 8, paragraph 12.
Where is the rejection order?
So that is page 52, 55. Two set, my lord, and now one set, my lord. Same petitioners. Two. The order is 15/5/25. Under 4 cases, counter blast, 4 FIR filed from our side, my. 3 earlier than the occasion and 1 is after the.
Five, 6, 7. What is the new ground?
New ground, my lord, will find page 8, paragraph 12.
What is the
Yes. Page 8, man. Detailed documents of Shahjahan so who were hospital respectively. Say Shahjahan was discharged and also say Shahjahan got discharged. One of the medical matter, the injury report which is already given, that is not supported by the medical subsequent discharge slip, minor. It is now 5 filed FIR negating the offense and accused was involved in the said offense. And due to the incident, most of the person from the petitioner side were injured and 1 person died due to sudden attack. But the accused group filed FIR lapses 4 days. The husband of the informant of Rupi case number named Hojgatale and his companions committed murder of the brother of the petitioner 5 named this.
We will call case diary, up-to-date case diary. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Ms. R. Deka, learned counsel for the petitioners. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Considering the fact that this is for the second time the petitioners have approached this court under section 482 of BNSS, perusal of up-to-date case diary would be necessary for consideration of the instant bail application. Hence, call for the same. List this matter.
8th of July.
Release this matter on 30 July.
Item 29.
Bail window. This is my lord second bail petition, my lord. Earlier bail petition was rejected, my lord, by rejection order, my lord, at least 13, my lord. The rejection, my lord, some of the accused has already. My lord, in the.
What is the new ground?
New ground, my lord, paragraph 9, my lord. But after arrest, my lord, some of the accused arrest, my lord, one of the, my lord, arrested, my lord, accused for forwarding report next, my lord. And my lord, in the meantime, my lord, investigation might have been progressed, my lord. Up to date CD may be called for.
Attack with sword and iron hammer, etc. Up to date CD, it was.
Heard Mr. A. Hussain, learned counsel for the petitioners. Also heard Mr. A.K. Parashar, learned additional public prosecutor. Call for the updated case diary. Release this matter again on when? 30 July.
Publish.
Item 30.
This case, my lord, third time, my lord.
Third time.
Only for health ground he has come at city level. I am not, but I know my position, my lord. Only city may be called after the city, my lord. And I will submit my, after the medical report also, my lord.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Ms. R. Dekar, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Call for the case diary and let the notice be also issued to the respondent number 2. In pursuant to the prevailing notification of the registry in this regard, the petitioner shall take steps for issuance of notice upon the respondent number 2 accordingly within 3 days from the date of this order, returnable on which date? 28 July. List accordingly.
This number, your worship, the regard case number, son. City of.
No, registry will verify file issue.
Item 31.
Okay. Okay.
Item 32.
May please, Lord. Lordship, with due instruction, humble prayer for order this.
Heard Mr. H.R. Ahmed.
Islam.
Heard Mr. J. Islam, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Highly obliged.
Item 33.
My pleasure. Lordship, Foxo is there, your lordship. CD may kindly call for a notice may kindly issue.
Heard Mr. A.A.R. Karim, learned counsel for the petitioners, issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall accordingly take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 29th of July. Stop. Let also the case diary be called for. List accordingly.
Item 34.
Obliged.
May please, your lordship. My lord, it's a poetic application, my lord, in connection with Amguri PS case number 10/25. Another bail application arising out of the same FIR is fixed on 16/7/25 for CD, my lord. Can it be taken up with AB number 1344/25, my lord?
Third, Mr. B.K.
RB Goham.
R.B. Gohai, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that another anticipatory bail application, that is AB number
1344.
1344/2025, arising out of same police station case, is pending before this court on 16/7/2025, and case diary has been called for in that case. He prays for listing this matter along with the said case. Prayer is allowed. Stop. Let the case diary be called for, and let this case be listed again on 16/7/2025, along with AB case number 1344/25.
Obligement. Item 35.
POCSO section is involved.
Not- Notice will go.
Notice manager and scan copy.
Charge sheeted case. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Since offense under POCSO is involved in this case, let notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall accordingly take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 4th of August. Returnable on 4th of August. Stop. Let also the scanned copy of the case record of the trial court be requisitioned. The registry to take steps for requisitioning the scanned copy. List accordingly.
Hello. Item 36.
None has appeared for the petitioner on call. Let this case be listed on 16th of July 2024. 25.
Item 37.
May I please the lordship. POCSO is involved in this case. Notice may be issued.
Heard Mr.
ATM Hussain.
ATM Hussain. Since offense under POCSO Act is involved in this case, let notice be issued to the respondent number 2. Where is the respondent number 2? You have not made the informant respondent. You have to make them party. Amend your petition. Learned Kati Dibo. Heard so and so, so and so. Learned counsel for the petitioner has prayed for filing an amended cause title in this case as due to inadvertence, the respondent number 2 has not been made a party in this case. The prayer is allowed. Let this case be listed again on when?
20.
No. You have to say when.
20.
20. On 20 July. Before this, stop. Before the said date. On 21 July. Before the said date, the petitioner shall file the amended cause title.
Item 48.
Please your lordship. Anticipatory bail application of a case POCSO my lord. You were shown as respondent.
Heard Mr. S. Nawaz, learned counsel for the petitioner. petitioners. Also heard Mr. K.K. Das, learned additional public prosecutor. This no. Why have you filed anticipatory bail?
Because for the offences, my lord, there is apprehension that if we appear, my lord, will be taken into custody.
No, but the court is empowered to grant bail.
Lord, my lord, but
Special-
considering the nature of the allegations and my lord, the gravity of the offences.
That is applicable to this court also. If that fear is before the trial court, that fear is before this court, you should also fear.
My lord, but then one thing which the trial court has not considered, my lord, perhaps at the time of taking cognizance, when they was, when I was shown as an absconder, my lord. That part has not been negated, that the IO cannot show me as an absconder, my lord. That part was not negated. Hence the apprehension.
You have a weak case. Khile. So, since offense under POXO is involved in this case, let notice be issued to the respondent number 2 in pursuant to the prevailing notification of the registry in that regard. The petitioners shall accordingly take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 5th of August. Let also the scanned copy of the case diary of Kosua PS case
110 of 2020.
110 of 2024 be called for from the trial court. Registry to take steps for requisitioning the scanned copy. List accordingly.
Item 39.
NDPS case lawsuit, the present petitioner lawsuit is the owner lawsuit. In fact, lawsuit is not the registered owner.
Charge sheeted case.
Hello.
Charge sheeted.
No, lawsuit is not yet submitted.
We'll call for the case diary. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the nature of offense involved in this case, let the perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the same. Let this case be listed again on 29 July.
Item 56 from supplementary list.
Please, your lordship. This is an anticipated bail application. Last Friday, it was listed before this court, lordship. Lordship, I have that day, lordship, I have submitted, lordship. I have taken, lordship, 60,000 for treatment of my mother, lordship. Within 3 months, I could not return that amount, lordship. But my bail petition was rejected. Anticipated bail petition was rejected on the ground of lordship, misrepresentation, lordship, as a Raju Ali, lordship. In this regard, lordship, I have already filed an additional affidavit, lordship. There I have annexed, lordship. I am myself is, lordship, Shahajan Ahmed, not Raju Ali, lordship. In support of that, lordship, I annex the Aadhaar card, lordship. Xerox copy of the Aadhaar card, lordship, additional.
Case diary is available.
My lord, not available, my lord, because it is today in my lord motion state.
We'll call for the
Yes,
case.
my lord. That's
Some
very called
protective
for.
lordship, which is admitted lordship, I have taken with my lordship. That's why lordship has, on the last day lordship, lordship was satisfied that on that ground I get the bail lordship. Because of that lordship, I have to prove that lordship, I'm not the Raju Ali lordship. That's why lordship, I filed an affidavit lordship. The last day lordship. Okay, lordship, it is in the record lordship. Because I have taken 60,000, not by saying I am a Raju Ali lordship.
When can you produce the case diary?
The short date, my lord, because my lord.
I'm on run, lordship. I have to arrange money, lordship. If things, lordship, if I'm
My lord,
on, I
regarding
cannot
the
work, lordship,
identification,
I
my lord,
can
this
pay,
matter is
lordship.
before this
Only
order,
my bail,
so I am praying.
even lordship, 35(3) notice was not issued to this petitioner, lordship. all this offense lordship, one punishment is for 7 years, one for 5 years, another lordship. If lordship, it is a misrepresentation lordship, cheating by personation lordship, then it is a lordship 5 years imprisonment and bailable one lordship. 319 of the BNS lordship.
Okay, let him appear.
My lord, here, my lord, other parties noted, my lord, regarding the identification, he has filed an affidavit, sir. So, my lord, my lord, pray for the perusal of this regard, and this is an AB, my lord. AB is just very short date, my lord, we will take the CD, my lord, in this regard.
When can you produce?
My lord, today is, my lord, 14th, so.
I'm ready to appear before the higher lordship. Let me place that
My lord,
lordship,
on
Aadhaar
18th
card
itself,
lordship.
my lord. This
So
would, my
once
lord,
your application has been rejected,
That lordship is a bailable offense lordship. That is for bailable offense lordship. If it is lordship a misrepresentation, that is cheating by personation lordship, it is a bailable lordship, 319 BNS lordship.
my lord, this week itself, my lord, on 18th, my lord.
May I pray lordship, I may be protected lordship in the meantime lordship. Because of the lordship, this case was listed on last Friday lordship.
no additional, let us peruse the case there. We are fixing a very short date. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Bosho, learned additional public prosecutor. Learned counsel for the petitioner has filed an additional affidavit wherein he has stated that his name is Shahjahan Ali.
Shahjahan Ahmed.
Shahjahan Ahmed.
Page 23 lordship, annexed lordship. Page 20
And
of the
has,
additional affidavit.
and he has not identified himself as Rajul Ali before the complainant. Stop. On the other hand, learned additional public prosecutor submits that as the trial court has rejected the bail application only because of wrong identity of the petitioner, perusal of the case diary would be necessary. He submits that a short date may be fixed on which he would be able to produce the case diary. Stop. Let the case diary be called for. Let this case be listed on 18th. 18/7.
In the meantime, lordship, some protection.
4 days. Wait.
Notice was not issued, lordship. That is not followed, lordship.
Wait for 4 days.
All right.
Finding item 14.
Your lordship will find page 9 and relevant portion page 12. Some narcotic drugs were recovered from house of one Mufasina Begum lordship, and the petitioner being her relative lordship, he was present in the house lordship. And it was lordship 10.51 grams suspected heroin lordship.
How much?
10.51 grams. Immediate quantity lordship, that commercial is 250 grams.
Since when you are behind the bar?
As on today, 44 days. As on today. Morigaon, my lord, short date.
44 days.
He said because my lord, he was present there, only because of that, my lord. That I am admitting, because very short date, my lord, on the same date, my lord, 18/7 from Morigaon.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Let the case diary be called for in this case. Let this case be listed again on 18/7.
My lord. All right.
Referring to the special variation right, item number 40.
My lord, this revision is arising out of my lord domestic violence case.
But who are you?
Lord, I am the father of the victim who was my lord minor at that time. And the petition was filed by the maternal mother of the victim.
Now, what is the status now?
Status, my lord, now I have filed a, my lord, guardianship case, guardianship and warden. But that is, my lord, is still pending, my lord. The site, my lord, now she is major, my lord, and she is under the custody of grandmother. My petition is pending.
Which order you have impugned?
I impugned order at page, my lord, page 48. Ask, my lord, the judgment of the lower court at page 32. And
Page.
we prepared an appeal. Appellate order is, my lord, at page 48.
What was the appeal? This is a revision against appeal.
Appeal. Petition against, my lord, appellate judgment. Appellate court's judgment. That is, my lord, page 48. The judgment passed by the, my lord, trial court, that is at page 32. And now our petition, my lord, under the guardianship petition, my lord, that is pending.
No, that is a different matter. Is there any hope of conciliation?
We are ready to take her. Is the, my lord, legitimate site of the petitioner, my lord. From the threshold, my lord, he is always ready, my lord, take her. But the maternal grandmother, my lord, he is not agreeing.
But the respondent number 2 has not yet appeared. If we refer it to mediation, who will issue notice to respondent number 2?
At this stage, my lord, she is along with her maternal grandmother, my lord, respondent number 2.
Respondent number 2,
Yes, she is the maternal grandmother, my lord.
Ms. Dimbeshwari Bora.
Yes. He is the, my lord, daughter of the petitioner.
No, but who will issue notice? We have to refer it to mediation.
My lord,
If there is a possibility of reaching an amicable settlement, otherwise not.
here in earlier order 1/2022, my lord, there it is reflected that is, my lord, notice is issued to respondent number 2 and 3. But in the cause list, my lord, from the end of the respondent number 2 and 3, my lord, nobody is, my lord, present.
No, whether notice has been served or not, there is no,
Perhaps in the office note, my lord.
there is no office note.
Uh,
Notice has been issued, but regarding
2022, my lord.
22, my lord, that was passed by this honorable court.
now what is to be done? What is your prayer? Heard Mr. S.A. Ahmed, learned counsel for the petitioner, who submits that. Also heard Mr. K. Bashir, learned additional public prosecutor. None has appeared for the respondent number 2 and 3. Learned counsel for the revisionist has submitted that since they are your relatives, respondent number 2,
Yes, my lord.
that there is a possibility of reaching an amicable settlement in this case. Hence, he submits that under the ongoing campaign dash mediation for the nation, comma, this case may be referred to the mediation. Learned additional public prosecutor does not raise any objection to the same. Referring to mediation.
Mediation, no objection. Oh,
Notice.
Respondent number 2. and
We
2
will
might have
issue.
represented.
Will issue
Yes,
notice.
yes.
Oh, yes, they are not represented. So what is their say?
Earlier, that's been taken.
No,
says,
no,
my lord.
no, you have to take fresh steps. However, in this case, it appears that respondent number 2 and 3 have not yet appeared in this revision petition, though this court directed to issue the notice way back in 1/2/2022. Hence, for ascertaining whether this case have elements of settlement in the presence of respondent number 1 and 2 would be required. Hence, issue notice to respondent number 1 and 2 afresh. The petitioner shall take steps for issuance of notice upon respondent number 1 and 2.
2 and 3.
Respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 4th of August. No, returnable on 8th of August. List this matter again on 8th of August. You issue notice, then we will see. If notice is served, we may again refer it to.
Obligement.
Item 41.
Yes, Mr. Vishwas.
Possible.
Possible. What is the case?
Maintenance matter, my lord, there was an order of the Lanet family court that I will maintain her 9,000 rupees per month. I am giving her. And I filed a restriction of conjugal right also. She has not complied with this order of the court, my lord. Honorable court said that I will purchase a.
But how to ascertain attendance of the
Now, my lord, we are living together, that's why. Let she
living
come.
together? You will inform.
Yes, your husband informed me, that's fine. Let she come, I will.
Heard Mr. A.C. Vishwas, learned counsel for the petitioner. None has appeared for the respondent. Learned counsel for the petitioner submits that the petitioner is the husband of the respondent and they are presently staying together, and there is every possibility of an amicable settlement in this case, and therefore he prays for referring this matter to mediation. Stop. Considering the submissions made by learned counsel for the petitioner, let this matter be referred to the Guwahati High Court Mediation Center. The secretary who will take steps for issuance of notice.
Mediation is doing.
The secretary of Guwahati High Court Mediations Center shall appoint a mediator and also take steps for issuance of notice upon the respondent. And thereafter report back to this court regarding the fate of mediation in the first week of September. List this case thereafter.
Item 42. If I am from for the opposite party, respondents, Lordship.
Who is for the petitioner?
Petitioner is the husband. Husband, I am for the wife. And Lordship, they have come for this revision petition for against the order of the interim maintenance by the Family Code number 2, Kamrup Metro. They have come against this. The court ordered that 6,000 rupees per month for the wife. They have come against that order. Lordship. That order
Is he paying that 6,000 rupees?
He is very recently he paid an amount of rupees 54 lakhs after 2 years, almost 2 years.
54 lakhs,
54,000, sorry.
1,000.
After about 2 years of that order.
Is there a possibility of amicable settlement?
My inception, Lordship, 6,000 rupees for a woman with her child, they want to deduct some more amount from that amount, Lordship.
But
Can
today,
it be possible, Lordship?
today the petitioner is absent.
Absent, Lordship.
We'll list it again.
Lordship, Lordship.
None has appeared for petitioner on call. Mr. What is
T.K.
it?
Mishra, T.K. Mishra.
T.K. Mishra appears for the respondent side and submits that the petitioner has filed this review application impugning the order of interim maintenance of rupees 6,000
per month.
per month, which was directed to be paid to the respondent by the petitioner. Stop. Since none has represented the petitioner, since no one is available for the petitioner today before this court, hence let this case be listed again on 30 July 2025.
Lordship.
Let us see.
Obliged, Lordship. Item 43.
Lordship, my lord, in this case, we have taken steps long back. But in the opposite, it is seen that the notice is not yet served upon the respondent. So if the respondent appears, then only the question of
Yes.
requisition may.
Unless both parties are
Yes.
before the court, how will we find out?
So my lord.
You
the
take steps.
Registry may be directed to inquire whereabouts the steps you have taken.
Notice has been issued to sole respondent. No, notice has been issued, but there is no report as
Yes,
regards.
that is-
You take fresh steps. Is there any interim?
No.
No. Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Though this case has been listed under for considering that though this case has been listed under the campaign dash mediation for nation, comma, for considering as to whether this case has any element of settlement so that it may be referred to mediation. However, the respondent side has not yet appeared. And unless the respondent is also before the court, the question as to whether there is any element of settlement in this case cannot be ascertained. On perusal of the office note dated 16/12/23, it appears that though the notices were issued to the sole respondent by registered post with AD as well as by usual mode, however, no report has been received regarding service of notice. In view of above, yes,
Yes, this will issue. In the meanwhile, LCR may be called for,
LCR has arrived.
right? But that is.
No, LCR not. LCR Ahane.
So.
It also appears that the LCR, that the trial court records, which were called for, have also not been arrived. In view of above, the petitioner is directed to take fresh steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 12th of August 2024. Let also reminder be issued for requisitioning the trial court records. List accordingly.
Item 44.
May I please, Your Lordship? In this case, Your Lordship, notice was issued to the sole respondent, but code is not yet received.
Yes. Respondent has to be there. Heard Mr. F. Hawk,
A. Hussain, Your Lordship.
A. Hussain, learned counsel for the petitioner. Also, none has appeared for the other side. On perusal of the order dated 16/12/2023, it appears that notice has been issued to the sole respondent by registered post with AD as well as by usual mode. However, no report as regards service of the same has been received. Though this case has been listed today for the purpose of considering as whether this matter may be referred to mediation under special campaign for mediation for nation, however, unless both the parties are present before the court, the issue as to whether there is any possibility of amicable settlement cannot be decided. Hence, the petitioner is directed to take fresh steps for issuance of notice upon the respondent by usual mode as well as by registered post with AD within 7 days from the date of this order, returnable on 14th of August 2024. Registry shall also issue reminder for the trial court records. List accordingly.
Timing item number 31.
Yes.
This anticipatory bail application is under section 482 of the person petitioner Junti Devnath has filed this application, Your Honor. He is arraigned in under section 3, 4, and 5 of Immoral Trafficking Prohibition Act, Prevention Act, 1956, Your Honor. The FIR, Your Honor, that is in page number 7.
Now, what is your case? We have to peruse the case diary.
Your Honor, on submission, Your Honor. Actually, Your Honor, his wife, Ritu Soikia, has been arrested already 16 of the 25, Your Honor. Children, 2, Your Honor. So he is also apprehending the arrest, Your Honor.
His wife is, of course, languishing almost 1 month in the jail as of today. Now,
Oh,
his wife also is not in a position that she should be given any protection.
why bail was rejected?
This is except Your Honor, it was filed, this FIR was written by the police itself, Sophia Police Station. They had got the information that they are running some unauthorized brothel system, not exactly, but they are engaging some girls or married women like that.
Case diary, not without case diary. Heard Mr.
That's not true.
S. Nath, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Considering the nature of offense involved in this case, perusal of the case diary would be necessary. Stop. Hence, call for the same. Please this matter. 25th of July.
Bail hearing be item 45.
Well, succeeded case, the Foxo Act. The petitioner was arrested on 18/2/2025. And the trial is almost on the verge of completion. There are 8 witnesses. Out of 8 witnesses, 4 has been already examined.
Victim?
Victim
Victim?
also examined. Kindly consider that aspect of the matter.
Victim
Sir.
has implicated you.
My lord,
She has implicated you. What is your case?
my case is it takes goes back to 20 years ago, Father, Victim's mother, the informant, and informant's father, raped his own daughter, And in the village, the decision was taken to cut the hair of the father of the informant. The petitioner was one of them, who cut the hair of the father of the informant. That was the grudge, Lordship, kindly peruse, the last page, The statement made,
Which page?
last page, page 45, The actual case, how it has been, engineered. Page 45, Assamese version.
No, where is the FIR?
The fire, page. Page 19 is the type 4. Assamese version, the Lordship, and page 23.
It is a case under which provision? 8.
8 and 10.
Eight.
It is
Heard. Which item?
45.
Heard Mr. P. J. Soikia, learned counsel for the petitioner. Also heard Mr. K. Bosher, learned additional public prosecutor, as well as Mr. S. Das, learned amicus curiae appearing for respondent number 2. Learned counsel for the petitioner prays for some time for filing the rejection order of bail by the trial court by way of an additional affidavit. The prayer is allowed. Let this case be listed again on when? You suggest
Next Monday,
on 21/7/2020. Right.
Item 46.
May I please order? Yes, please, okay.
This is NDPS matter.
NDPS commercial quantity.
Only total three.
How much time will you require?
Give a short date, my lord. I will go through that, my lord. Any date, my lord.
Okay. Heard Mr. P. D. Bhuyan, learned counsel for the petitioner. How many petitioners are there?
One petitioner, my lord.
Petitioner.
Is already given.
Also heard Mr. K. Bosher, learned additional public prosecutor, who prays for some prays for an accommodation as he could not go through the scanned copy of the case trial court records. Stop. He prays. Stop. Considering the submissions made by learned additional public prosecutor, let this case be listed again on suggest 17 on 17/7/2020.
Item 47.
21 G, my lord. And this article, my lord, as per my lord, order dated 28/5/2025, my lord, case 19, my lord. That is clear mention, my lord. That weight of the among the mixture of the cis neurotic physiotherapy substance or is 8.3 gram, my lord. And as per my lord, NDPS Act, 5 gram is small quantity. So that difference is
What is the contraband?
determined, my lord, the
Heroin.
heroin, my lord.
Okay.
That is, my lord, difference is 3 gram, my lord. Intermediate quantity, my lord.
Since when you are behind the bars?
27/5/2025, my lord.
How
That
many
is
days?
49 days, my lord. 50 days. 2 days is 50 days, my lord. 27/5/2025.
Yes, what's case diary
Yes,
says?
in the Procedural lordship, these persons' names are there, Manoj and this one, Rina Majumdar. Again, in this house, they found a person lordship. Again, the co-accused also stated that these two, all the persons are involved and knowledge is there. However, FSL is not there. Again, the case is pending lordship. They stated that the source has been engaged to trace out the origin of the drug trafficking. Which is on that stage, Lord. Investigation is going on to trace out the origin of the drug trafficking.
No, my lord.
Suppliers of the.
Oh, my lord, that is the involvement is some witnesses, Latif Ali, man. He is involved in the case, my lord, but he is the main culprit, my lord. He had no knowledge about the heroin, my lord. In how can drop this drugs, my lord, in his house? When police sees the heroin, my lord, in his residence, and Rina Muzumdar is the housewife, my lord, not involved in this case, my lord. And another thing not receiving the heroin is not received from the position of the accused person, my lord. They are recovered from the house of the accused person, my lord. And they have no knowledge about this heroin, my lord. You can drop this, it, my lord.
Okay.
And they are doubt the Latif Ali drop this materials, my lord, in their house regarding contradictory, my lord.
Investigation is pending for FSL as well as for
Origin of the drug trafficking.
locating the origin. Heard Miss R. Kalita Lenin, counsel for the petitioner. All. Yes.
My lord, they are already keeping. So, my lord, maybe allow, my lord. And difference is on 5 gram is the small quantity. They are released on same day, my lord.
Also heard Mr. K. Das, learned counsel for the petition, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Reena Majumdar, Manoj Mali alias Garo, and Amar Majumdar, who are detained behind the bars since 27/5/2025 within bracket for last 49 days in connection with Palaswari PS case number 147/2025 under section 21B/29 of the NDPS Act. The gist of accusation in this case is that on 27/5/2025, one Amarjyoti Kakoti of Vijayanagar Police Outpost had lodged an FIR before the officer in charge of Palashwari Police Station, inter alia, alleging that on receipt of an information through reliable source that the petitioner number 3, namely Amar Majumdar, is involved in drug peddling from his own residential house and a search team was conducted and it went to the residence of Amar Majumdar on the same day at about 1:10 p.m. And during search operation, heroin was 81.
81 that along with container, my lord. That only heroin is weight, my lord. Before the judicial basis first class, my lord. Kindly order see the annexer, my lord. Annexer 3, page 19, my lord. Page 19, it is clear that IO has produced the following narcotic hereditary substance, controlled substance, a scaled yellow package containing 61 number of plastic, a valve containing brown color.
Okay.
Last 9 minor substance is 8.3 gram along with the blank plastic. Order of prayer or drawn sample, my lord. Now as per the prayer of Heinous, the total weight being 8.3 gram, my lord.
During search operation,
8.3 gram, my lord.
81.32
That is the along with container.
grams of suspected heroin along with the plastic container was found from the residence of petitioner number 3 and the other petitioners who were found in the residence were arrested therefrom.
That weight is, my lord, 8.3 gram, my lord.
Learned counsel for the petitioner has submitted that the quantity of heroin recovered from the house of petitioner number 3 is only 8.3 grams as revealed
Wait, my lord, before the magistrate, my lord.
From order dated 28/5/2025 passed by the learned Judicial Magistrate First Class Amingao in Palashwari PS case number 147/2025. She submits that the petitioner number 1 is a housewife and is in no way involved in the offense alleged in this case. She also submits that considering the quantity of contraband seized as well as period of detention already undergone, the petitioners may be allowed to go on bail, as the maximum period of detention in this case, which statute allows, is 60 days only. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Palashwari PS case number 147/2025 and has vehemently opposed the grant of bail to the petitioners. He submits that during investigation, sufficient incriminating materials are found against all the petitioners and the contraband was seized from their possession. Stop. He further submits that though the investigation has fairly progressed, however, same is pending for receipt of FSL report as well as Also for tracing out the origin of the contraband. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record, including the case diary. Stop. Though there are incriminating materials against the petitioners in the case diary, however, considering the fact that the seized contraband is only 3.3 grams more than the small quantity, as well as considering the fact that the petitioners are detained behind the bars for last 49 days. Also, also considering the progress made in the investigation, this court is of opinion that, this court is of opinion that if the petitioners cooperate in the investigation, their further custodial detention may not be necessary for fair completion of the trial, for fair completion of the investigation of the Palaswari PS case number 147/2025. Stop. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the learned special judge Kamrup Amingao with following conditions. Number 1 and 2. Send back the case diary.
I did.
This bail application is accordingly this also.
I did.
Item 48. It is not available. They collected matters, arising out of sale of power. There are also intermediate quantities that 11 gram of suspected heroin along with the plastic bags. And they are in custody for 48 days as of today. And admittedly from item number 1, that is Lukman Hussain, from him nothing was recovered, Lordship. Lordship, may I kindly see that page 21. And page 22 is the vernacular of the seizure list.
Item number?
Item number 48. Seizure list, page 22, last line, your Lordship. Is from the possession of Dr. and he is Lukman Hussain. And in the FIR also, it was stated that in FIR, your Lordship will find page 14, last.
Then why are you arrested?
He was present at the place, Lordship. That your Lordship will find page 14. FIR.
Page?
Page 14. Second last paragraph, Lordship.
40?
14. After the 2 apprehended persons were made aware of section of the 50 NDPS Act, in Lordship submit, I'm just placing my case for Lordship because I'm on delay part also. On first day also, they said Lordship short date may be given, therefore this matter was fixed today, Lordship. And they opted to be searched in the presence of the undersigned. During the body search, a cream color soap case was found inside the right pant pocket. Inside the soap case, a transparent plastic packet containing suspected NDPS drugs were recovered from Dr. Ali, but no incriminating substance was found from Lukman Hussain.
Then why are you arrested?
Because he was present there. That is, it was recovered from his pant pocket. How you will know what is there in his pants pocket or in the person from the other person's pocket? There was nothing at 48 days. And short day today was fixed for case, you're considering that part. They were given opportunity.
Yes.
Only 12 days late.
Why case diary is not there?
Lordship, we have still they are given, Lordship, on 36.
What is the response?
We have not got any response, Lordship. We will fix short date, Lordship. Last chance we have given, Lordship.
No.
Because
Why IO has not responded to your requisition?
they have given the signal on the 30th of June, my lord, and Yes, in both the cases. Both the cases. Maybe fix on Wednesday, my lord.
Wednesday, Lord.
Cyber PS
No, but this case is different. In this case, the petitioner was not found in possession. We are granting bail in this case. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for this application under section 483 of BNSS has been filed by the petitioner, namely Lukman Hussain, who has been detained behind the bars since 28/5/2025 within bracket for last 48 days in connection with Sapor PS case number 80/2025 under section 21B of the NDPS Act. The gist of accusation in this case is that on 27/5/2025, one M. Millie, SI of police of Sapor PS had lodged an FIR before the officer in charge of Sapor police station, inter alia, alleging that an information was received from reliable sources that some persons are dealing with some persons who are dealing with narcotic substance will be coming to area Jhar area, and accordingly a search team was constituted. During search operation, 2 persons were apprehended, including the present petitioner and petitioner stop. It is further stated in the FIR that from the co-accused, namely Bakkar Ali, 1 plastic packet containing suspected NDPS drugs were recovered. And nothing was recovered from the possession of the present petitioner. Learned counsel for the petitioner has submitted that the present petitioner was arrested only because he was found along with the co-accused, though nothing was recovered from his possession. He further submits that 11 grams of suspected heroin along with plastic packets were recovered from the possession of Bakkar Ali, and he also submits that the petitioner has been detained behind the bars for last 48 days, and considering the fact that nothing was recovered from his possession, the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that some more time may be granted for production of the case diary. He submits that though requisition for case diary was made on 36/2025, however, no response has been received from the investigating officer of this case. Stop. I have considered the submissions made by learned counsel for both the sides and gone through the materials on record. The prosecution side has failed to produce the case diary in spite of the fact that this is for the second time. No, first fact that today was the specific date given to it for production of the case diary. it also appears that the investigating officer has not responded to the requisition made by the Office of the Public Prosecutor, and no valid cause has been shown for the same. Under above circumstances, considering the fact that this case involves heroin, involves contraband weighing about 11 grams
Along with plastic bag.
only with the container, and also considering the fact that the petitioner, that nothing was recovered from the present petitioner. This court is of opinion that as no, before that. Moreover, this court also takes into consideration the fact that the petitioner has been detained behind the bars for last 48 days. Under aforesaid circumstances, if the petitioner cooperates with the investigation, his custodial detention may not be necessary for fair completion of the investigation in this case. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge.
Subdivisional Judicial Magistrate, Bilasipara, Dhupi.
No, it will be before the special judge.
He was produced before the SDGM, that your lordship is 17.
But case will,
That will be. Special judge Bilasipara.
there is a special judge,
Additional
special judge Bilasipara, Dhubri, with following conditions, number 1 and number 2. This bail application is accordingly disposed of. In second case, we are giving time
on
for,
what days they can produce, they say, lordship.
okay. In next item number 50, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on when?
17 lordship.
17/5. 17/7/2020.
Problem.
This case, CD not received, my lord, today. 7 days today.
What is the offense?
Offense, my lord, intermediate contravention, suspected brown sugar, my lord. 10.0.
How much?
10.06. 06.
What do you say?
My lord, CD, I have that now again and inquired, my lord, CD not. Otherwise, my lord,
Where is the rejection order?
my lord, days 20 and 21. They approach 2 times.
Heard. This is item number 50.
49, my lord.
49. Heard Mr. K.U. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Noor Muhammad, who has been detained behind the bars since 18/5/2025, within bracket, for last, how many days?
57 days.
For last
As on today.
57 days in connection with Kolgosia PS case number 56/2025. The gist of accusation in this case is that on 17/5/2025, one Binoy Nath, SI of police, had lodged an FIR before the officer in charge of Kolgosia police station, inter alia, alleging that on receipt of an information through reliable source that one Noor Muhammad, within bracket present petitioner, is storing and selling NDPS, is storing and selling prohibited contraband from his own house, a search team was constituted and a search was made in the house of the petitioner. Stop. During search operation, 10.06 gram of suspected heroin was suspected brown sugar was recovered from the possession of the present petitioner. Learned counsel for the petitioner has submitted that the quantity of contraband seized in this case is intermediate quantity, and hence the statutory period of detention is 60 days. However, he submits that the petitioner has already completed 57 days of detention. Hence, he prays that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has prayed for some more time for producing the case diary. Stop. I have considered the submissions made by learned counsel for both the sides. Stop. Though the case diary is not available before this court, however, from the materials available on record, it appears that the petitioner has been detained behind the bars for last 57 days, and considering the quantity of contraband seized in this case, that is 10.06 grams of black sugar, the maximum period of detention for which the petitioner may be detained during investigation period is 60 days only, and he has already been detained behind the bars for last 57 days. Stop. Hence, considering the period of detention undergone by the petitioner, he is allowed to go on bail. No. Hence, considering the period of detention undergone by the petitioner, this court is of opinion that further custodial detention of the petitioner may not be required for fair completion of the investigation of the aforesaid case. Stop. Accordingly, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge Borpeta, with following conditions, number 1 and 2. This bail application is accordingly disposed of.
51. 51, my lord, otherwise earlier CD was available, but session was available because of that up-to-date CD was called for. The up-to-date CD not received, my lord.
My lord, also after granting petition by your lordship on 14 and 16 April, I appeared before the also the
14.
14 and 16 April, I appeared before the
When you were granted interim protection?
also granted, my lord,
From 10.
What is the offense?
stealing and slaughtering of the cow, my lord. For the petitioner is concerned, there is no specific allegation against him.
You have appeared before the IO.
I appear on 14 and 16, I appear. on 49 appeared, then the IO told him to again appear on 16, and on 16 I appeared again.
Okay, heard Mr. FKR,
As per his statement, my lord.
FKR Ahmed, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor, who submits that the up-to-date case diary was called for, however, same is not available, and prays for some more time for producing the same. On the other hand, learned counsel for the petitioner has submitted that the petitioner was granted interim bail on 10/4/2025 with certain condition, and the petitioner accordingly appeared before the investigating officer on 14/4/2025.
16.
Stop. On that day, he was asked by the IO investigating officer to come again on 16th. Accordingly, he again appeared before the investigating officer on 16th of April 2025. Your statement was recorded.
So I've been recorded by the understanding the statement.
Learned counsel for the petitioner has also submitted that the statement of the petitioner was also recorded by the investigating officer. Considering the submissions made by learned counsel for the petitioner, which shows that the petitioner has complied with the directions of this court and has cooperated in the investigation, comma, the interim bail granted to the petitioner by this court by order dated 10/4/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This anticipated bail application is accordingly disposed of.
Right.
Yes, Lordship. Just before Lordship, my working as a last mandal in the revenue circle. The fire has been lost before the Regional Anti-Corruption Department, officer in charge of Regional Anti-Corruption Department, I1, John Kumar Das, my lord. This is page 18, my lord. Allegation is that, my lord, I have enriched, my lord, beyond my
Disproportionate income.
disproportionate income, my lord. But this facts, my lord, is not correct, my lord. Because, my lord, lordship may come to the FIR, my lord. Page 18, my lord. There is some secret information 8/12/2021, my lord, as per the FIR. So thereafter, Gov PE 4/2002 has been initiated, my lord, in 2002. Now, my lord, after the 2024, on 27 January, they have closed the FIR, my lord. So here allegation is, my lord, I may read, my lord, in the course of inquiry, second paragraph, my lord, the FIR.
Yes.
In the course of inquiry above noted PE, it is learned that there is a 3-story building, the big size 300 square feet actually in each floor, surrounded by concrete boundary wall with iron gate in entrance, roadside facing, and found in the name of the super suspect officer, SO, Sikusheshwar Dotto, Latmandal, Bipura Revenue District, Lakhimpur, Assam at Harmoti Center, Utibari, Harmoti under Laluk Police Station, that at Lakhimpur, Assam. During inquiry, it is also come to light that the SO Kusheshwar Dotto, Latmandal, Bipura Revenue Circle, Lakhimpur, Assam is a big size residential compound with modern house facilities with a multiple carting plus place surrounded by the Pakka boundary wall, which is located at Vibosti, nearby National Highway 15 Harmoti under Laluk Police Station, Lakhimpur, Assam. It is also confidential learned during the inquiry that Associate Kusheshwar Dotto Latmandal and the circle, Lakhimpur, Assam had acquired more land and landed property commercial, meaning it Lakhimpur district as well as in Guwahati, my lord. In this, my lord, paragraph 1, my lord, I admit there is a building, my lord. But I have the ability to construct a building, my lord. This is not 3-story, my lord. That time when allegation is made, my lord, it is 2-story, my lord. Second, my lord, regarding my lord, having land at Lakhimpur and Guwahati, I deny, my lord. And secondly, my lord, the land, other land is belong to my wife. She is an advocate by profession. My lord, she purchased the land by her own, my lord, source of income. So, and the other narrative, my lords, the other narrative, my lord, the compound and all parking area, these are false, my lord. Only Assam price house, my lord. Yes, my lord, the area of 1 acre of land is bounded by my lord, my lord, RCC wall, my lord. That is true, my lord. Except that rest are I denied, my lord. And I have filed additional affidavit also. Lordship, I joined in the service, my lord, from 2006, my lord. Prior to joining, I was in my lord, Itanagar. I have a personal business, my lord. So prior to that also, I have some, my lord, amount of money, my lord, near about.
No, this FIR is of 27 June 2024.
My lord.
For last 1 year, you were not arrested.
No, my lord.
Then why are you
My
apprehended?
lordship, I come to last page, my lord. Page 22, my lord. My apprehension is because that the Superintendent of Police Director of Vigilance and Anti-Corruption wrote a letter to the Superintendent of Police Director, my lord, this Simantapur, my lord, District Commissioner Lakhimpur, my lord. So in this letter, the information has been sought, my lord, regarding this 127, my lord. Then my lord, the revenue officers, my lord, inform me, my lord, that this kind of information is required. Then I come to know about the lodging of this murder FIR. Then I got a certified copy. Then I have approached on our lord. My apprehension is that, my lord, I am ready to cooperate. And
No, but for last 1 year, you were not arrested.
No, my lord. My lord.
Did you?
That is a maybe, my lord. Because, my lord, in case of, my lord, anti-corruption, my lord, this kind of cases, my lord, CBI, immediately never arrested. They will call up, my lord, for, my lord, verification, all this. After that, my lord, we are not sure that whenever we appear, they may be arrested. I may be arrested, my lord, whenever I appear. It is not that in general police, they swinging to action, immediately arrest, my lord. Basically, in case of this, my lord, regarding, my lord, the anti-corruption. So that's why, my lord, they have sought all the information. If the information, my lord, received, they found to be, my lord, some disproportion, definitely they will arrest me, my lord. So my apprehension is that, my lord, the property belongs to my lord.
This letter was written to Deputy Commissioner.
Deputy Commissioner.
Then Deputy Commissioner informed you.
My circle officer. The circle officer informed me, my lord.
Okay, yes.
My lord, otherwise, my lord, should be, my lord, earlier 2 occasions I have produced this, but at point of time, my lord, I have given one information which is provided in the CD.
Now you are in service or retired?
I'm in service, my lord. I'm regularly in service. Only my age.
Where are you posted now?
Now my people are revenue circle.
But by checking the, my lord, pen number, petitioner and her wife, and for some list of but mentioned in the, my lord, CD that 23 numbers of life insurance and 10 numbers of bank account. Yes, file additional affidavit and denying those, my lord, obviously stated that 3 numbers of bank account and 4 numbers of LIC and RBI. But police, though, give those details only the life insurance company name and the bank account number. But how much amount, what is the details, that is not yet provided in the CD. I've gone through. And now, he has given the, I've checked the additional affidavit.
The balance sheet also I have provided, my lord. I have annexed.
That information is not in the CD. Regarding.
No, you need his custodial interrogation.
So
If he cooperates,
yes.
if he provides you all the documents, then if case is filed found against him, you file charge sheet.
As far as well as he is still working as far as. This cooperation is very much necessary.
Ready to cooperate, any condition, my lord.
Heard Mr. M. Soronia, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Kusheshwar Datta, who is apprehending his arrest in connection with ACB case number, ACBPS case number 52 of 2024 under section 13 within bracket 2, read with section 13 within bracket 1 within bracket small b of Prevention of Corruption Act. The gist of accusation in this case is that the petitioner is presently working as Lat Mandal in the office of the circle officer, Bipuria Revenue Circle in the district of Lakhimpur, Assam. Stop. On 27/4/2024, one Shri Jayanta Kumar Das, Inspector of Police, Vigilance and Anti-Corruption, Assam, had lodged an FIR before the officer in charge of ACB Police Station, Directorate of Vigilance and Anti-Corruption, Assam, inter alia alleging that the petitioner is having disproportionate asset to the known source of his income. It is also alleged that he has landed property at Bipuria, at Lakhimpur and Guwahati.
I deny the.
Stop. Learned counsel for the petitioner has submitted that the FIR is mainly lodged on the basis of a preliminary inquiry which was conducted in the year 2022. 22.
My lord. 4/22 preliminary inquiry, but information is 08/11/2021.
Which was conducted since the year 2022. Learned counsel for the petitioner has submitted that the petitioner does not have any landed property at Guwahati as alleged in the FIR,
As well as in Lakhimpur.
as well as in the Lakhimpur. He also submits that he is presently working as Lat Mandal in Bipuria Revenue Circle in the district of Lakhimpur, and if he is arrested, his service career would be jeopardized. He further submits that he is ready to cooperate in the investigation and provide all necessary, all relevant information / documents which may be required for the purpose of investigation. On the other hand, learned additional public prosecutor, Mr. K.K. Parashar, has produced the case diary of the
CBPS case number.
ACBPS case number 52/2024. You are opposing
Malad, open.
and has opposed the grant of bail to the present petitioner on the ground that there are sufficient incriminating material in the case diary. He submits that many required information for the investigation is yet to be furnished by the petitioner to the investigating officer, and hence he submits that if bail is granted to the petitioner at this stage, the investigation may be jeopardized. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case record of case diary which was produced by learned additional public prosecutor. I have also gone through the additional affidavit filed by the petitioner in which he has given the details of LIC policies and other assets of the petitioner. Stop.
As well as bank account.
As well as bank account numbers. It appears that the FIR in this case was lodged in the year 2024, lodged more than 1 year ago on 27 June 2024. And since then, investigation is going on. Considering the nature of accusation made against the petitioner, this court is of opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the aforesaid case. Stop. In view of above, the above named petitioner is directed to appear before the investigating officer of ACBPS case number 57/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with ACBPS case number 52/2024, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. This anticipated bail application is accordingly disposed of. Send back the case diary.
Hello, blessings.
Matter 54.
Charge sheet submitted. You're on interim bail. You appear before the heard Mr. H. Agarwal, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number considering the fact that the charge sheet has been laid, this anticipatory bail application has become infructuous and accordingly disposed of.
Matter 55.
Otherwise, it is pending investigation. Case is pending investigation. Then you bring the case diary instead of scanned copy. Heard, Miss, what is your name? A. Parashar. A. Parashar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar.
18th of July.
Will it be possible? Let us see. 23rd. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 23rd of July for case diary.